Manchego cheese case in Costa Rica, and we have this is the how it is presented in Spain. The decision was of 2014, and it's the vote 702. I was a judge at that time at the tribunal. And I would like to explain very quickly how is the system in Costa Rica. We have a national register system, and the national register has among the registers, it controls the industrial property register and the copyright register, but we have other registers there like the property register, corporation register, and so on. And this it's ascribed to the Ministry of Justice. And in the year 2000, by law, the Administrative Registration Tribunal was created. So it's an administrative tribunal that will review in appeal all the appeals related to public registers, and that is where this resolution was taking place, because that's the way all the administrative procedure finishes. But it's very important that normally there is these cases will not go to the contentious administrative procedure. The decisions of this tribunal are normally well accepted in the country, so we have a quick resolution of the cases. So now I'm going to talk about the Manchego cheese case, and it was known as the opposition of the registration of a GA, the GA sign Manchego in Costa Rica, that was accumulated with the application of the trademarks. One is called Manchego Los Alpes, that we are going to see it here, Manchego Los Alpes. This company wanted to register this trademark, and then another company wanted to register this Manchego Monteverde, and here says cheese type Manchego Monteverde. And if you see the design, it's not so clear to see, but here it's a description that says it's a mature cheese and it's a hard cheese. And then we have this, the Dos Pinos is a very well-known cooperative in Costa Rica, the larger milk producer, and they wanted to register the trademark Manchego as it is there. So who is the applicant for this GA? Of course, is the delegation of the European Union of the Republic of Costa Rica. And what they were asking as legal background for that is a partnership agreement between the Central American and the European Union that we are going to call the AAQ. And there was the list of this GA to be registered. And then we have also the Trademark Act in Article 21. And we have a very specific decree that is the 33,743 of the COMEX, that is in the Ministry of Trade, that we are going to analyze, that is the REACH, that was created in the year 2007. So the opponents wanted to register their trademarks according to the Trademark Act. And what they were asking for that is they were arguing that that was a generic term, Manchego cheese, as a generic term that is included in the trademarks. The first resolution was of the Register Public Industry Property that rejected the trademarks and granted the GA requested by the European Union. And the tribunal knows this case because of the appellation. Which is the terms, which are the facts that the tribunal considered very important? In this case, the decision was based on these facts. The first is that the term Manchego is officially recognized since 1984 by the Spanish government, and that the European Union also have recognized it as a geographic indication. So in Spain was an appellation of area, origin, protection, and then the European Union granted GA. And the other aspects that were very important are the facts that were not tested, because the discussion was related if it is a generic term or is not a generic term. So for the tribunal, it was not proof that the term cheese manchego is known in Costa Rica as a common and generic name for a type of cheese. And the other thing that was not proved is that the public in Costa Rica do not have any awareness about the existence of the term cheese manchego as a distinctive sign, GA, coming from Spain. The grievance of the parties are as follows. For the very important cooperative Dos Pinos, the first grievance was that they have been using in good faith the term manchego in their label in their products, and that the trademark law allows to use certain geographic indications included there, or terms related to geographic areas. And they argued that there was no deceit to the consumer because the label is not associated with the Spanish products. And we see that their label is very general, very generic. I will show their label again for you to see it. Is this. So that was the first argument for them. And then they will say that because of that, because they have been using manchego in their labeling, then the geographic indication asked by the European delegation will not work as a geographic indication, requiring all the requirements of geographic indications, because in Costa Rica, people will not relate the term manchego to that cheese coming from Spain that have a special qualities. And the other thing they say is that their brand is very valuable, that they have been selling cheese, and they have having important income for selling the cheese labeled with manchego. The other company, Productos Lácteos Los Alpas, they were using other argument, and that was of the article 246 of the ACU that we are going to analyze forward. And what they were saying is that manchego cheese is already considered generic in Costa Rica. And there were a lot of importations of this cheese, and they can prove it that custom control information technology system proved that it has been imported from other countries, not only by Spain, but from the United States. And they are arguing that they want to register the trademark because since 2004, they have been using the label. Then what is the elements that are considered by the tribunal? The most important element is that the trademark act already says that the indication, a GA, will relate to a good that is originated in a territory of a country, region, or locality that have a given quality because of that origin. And that should have a protection if not only if it's the case of a Costa Rican GA, but also from indications coming from abroad. And the other element that is considered by the tribunal is the importance of the GAs, because they are considered as a public good. They are related to a community. They are considered national heritage of that community, and they have a public organization that is controlling it. So that gives them a great importance. And then there is a public interest involved relating to them. And because there is a big important public interest related to a whole community, and because of the increase of the use of GAs in international markets and globalization, is very important to have a good control of this, and it's very important to give protection of the veracity and transparency of international trade. So these are elements that are considered very important for this decision. The other thing is that the region, that is the decree that I commented before of 2007, has a very strong, grants a very strong protection to the GAs coming from abroad. Generally, the GAs, they said, is protected for any kind of use that can create take advantage of the reputation of a GA. Is protected, the GAs are protected against any kind of usurpation, limitation, or evocation. and that will deceive the consumer about the true origin of a product. And the other important protection is if there is a false or misleading indication concerning the source of origin. So in general, this decree protects again any misleading information to the public that is due because of use of terms that might be related to a geographic indication. The other element that is considered by the tribunal is that the Paris Convention has already stated long time ago that the trademarks are prohibited if they include indications or allegations that is mislead the public of the nature, manner of manufacture of the goods. So there are very important public interest to protect the public against any misleading information. And then the other important element that is considered is the TRIP agreements, Article 21, that obliges the members to prevent the use of any means which in the designation or presentation of the product indicate, suggests that the product in question comes from a geographic region other than the true place of origin. So these regulations are very clear to protect against any use of a geographic name that will mislead the public and also will create an idea that the product is coming from another region. And the other aspect is the AAC AQ, Article 246, that also established that the GIs listed in the annex should have a protector. The use of any means, so they should grant protection for the use of any means which in the designation or presentation of the product indicates or suggests that the product in question comes from a geographic area other than the place of origin. And also there is a protection against any type of evocation, like that the product is style, type, imitation, or for another product that have a geographic protection of a geographic indication, and any other practice that may mislead the consumer. So this aspect will grant a protection to the GA Manchego, because in Costa Rica, as a Latin country that speaks Spanish, and that we have a very important part of our formation, as we're going to see in education, the study of Don Quixote de la Mancha is very well known for the public, the existence of the place La Mancha, and the existence of the cheese that is coming from that place, because it is related to that book. The main objection given to the protection of GA is coming from the AQ in the Article 246, that says that when a GA contains a name that is considered by generic in a party, the use of that generic name in the appropriate product in the party shall not be considered to be contrary to the article. That was the main argument, since the opponents were saying that they have already been using the name Manchego to indicate a generic product. And the other element that they were saying is that for the GAs other than wines and spirits, nothing in this agreement shall be interpreted requiring the party to prevent, continue, and similar use of a given geographic indication of another party in relation of goods or services by one of national or residents to have used the geographic indication in good faith. So this was the main argument that have to consider the tribunal. And in Costa Rica, because the term Manchego related, it's an adjective that relates to La Mancha, it was considered that the public will be deceived if they put in a label the term Manchego related to a cheese, because the people will infer that the cheese is coming or related to that area. And because of that, the tribunal rejected the registration of the trademarks. Another very important aspect here is that that was already a decision in Costa Rica that established a long time ago that Manchego could not be registered as a trademark, because Manchego is related to an origin, a region in Spain that is well known. And if they use it in a trademark, then that will mislead the public. And because of that, before they were using the term Manchego in their selling the products in Costa Rica, it might be considered that this use will not be in good faith, because already the tribunal, and that this decision is here, and that is a judicial court, is the High Administrative Court of Justice. It's not an administrative court, but it's a judiciary court, that in the decision that is 6,924 of the year 97 already said that Manchego is related to the origin of a place. And because of that, at the end, the decision was to reject the trademarks, because they consider that they are against the trademark and the general principle. The trademark will not mislead the consumers and will not mislead them related a place of origin. And on the other side, the GA was already registered a long time before by the European Union and also by the Spanish government since 1984. And because of that, it should be granted. And also in this, there is a note that I put at that time as judge, in the sense that the dictionary already says that Manchego is a place of La Mancha, is related to a place of La Mancha, and it do not be considered a good faith use of the term Manchego by the companies in Costa Rica, because of this decision that is of the High Administrative Court Tribunal, that had informed all the business community that the term Manchego is related to La Mancha and should not be used as a trademark. So that will be in synthesis this case. I appreciate much the opportunity to present it. And if there are questions, I will be very happy to answer them. So that will be my presentation, very short. Thank you very much.
Very short, but to the point. A well-argued case, as was mentioned by Virginia in the chat. Thank you so much for sharing that.